That is case number 117201 in the matter of Alvin R. Lundgren. I had mentioned when the docket was called this morning at 9 o'clock that there would be a recusal on this case, and I would announce our substitute jurist at that time. Justice Beyer is recused, and sitting in her place to my left, this is Judge Catherine Gardner, a judge on the Kansas Court of Appeals. She has read all the material. She'll be fully participating in the oral arguments and then also in the ultimate resolution of the case. As we did yesterday, Judge Gardner, on behalf of the court, I thank you for helping us out today.
You're very welcome. It's an honor.
Thank you. Counsel, one more matter, if I may. When the case was read at 9 o'clock this morning or a little earlier, Mr. Lundgren did not announce his presence. I do not see anybody seated at opposing counsel table, but let me make a general request. Is Alvin R. Lundgren in the courtroom? Very well, counsel, you may proceed.
May it please the court. The Office of the Disciplinary Administrator appears by Kimberly Knoll, Deputy Disciplinary Administrator. As the court is aware, this is an original proceeding in attorney discipline. We had a hearing on October 6, 2016. Mr. Lundgren did appear at that hearing and he did offer testimony. It is my understanding that he advised that he was not intending to appear here yesterday. Our hearing panel found that Mr. Lundgren was admitted in 4 states, California, Utah, Missouri, and Kansas. In 1998, his California license was suspended for his behavior of engaging in the unauthorized practice of law. And then in 2000, the Missouri Supreme Court also disciplined him for the same engaging in the unauthorized practice of law from California. Subsequent to that, there was a complaint that was filed with the Utah Office of Professional Conduct. That complaint resulted in findings that Mr. Lundgren violated 1.15 when he misappropriated client funds, that he provided false information during his admission process, and that he engaged in general misconduct. During that hearing, Mr. Lundgren advocated that he had no history of any attorney discipline. He was disbarred in the state of Utah, and subsequently the state of Missouri disbarred him. While the Utah case was proceeding, he voluntarily surrendered his license to the state of California. And on that form, under the penalty of perjury, he advised California that he was not currently under any kind of attorney disciplinary proceeding, which was false. California did accept his voluntary resignation. He then appealed the Utah disbarment, and the Utah Supreme Court found that during his disciplinary hearing, not only did he admit to converting the complainant's funds, but over a 4-year period, he converted other client funds, and that he used that money for personal use. The Utah court found, based upon his assertions, that he did not have any prior attorney discipline, and they ordered him to be disbarred. To Kansas, the respondent did not self-report any of his disciplinary actions. We learned of the Utah proceeding from the Utah Supreme Court, and then our office uncovered all of the other disciplinary actions. Our hearing panel found that he converted funds, engaged in dishonest conduct, and made false statements during the disciplinary process. The panel also found that he failed to report and he failed to update his address. And as of today, his registered address is still an address that he abandoned several years ago. Service was effectuated by this court based upon the address that he provided during the hearing, and clearly, because he did advise that he wasn't going to appear here, he was aware that this matter had been set. The panel recommended that he be disbarred, and that remains the recommendation.
Counsel, just to add a little more specificity, can you tell us how Mr. Lundgren was advised of the hearing today?
Yes, Your Honor. A court clerk received a call from Mr. Lundgren. This is an email that was sent yesterday at 11:28 a.m. And it says, Mr. Lundgren is scheduled for oral arguments on the disciplinary matter tomorrow, 5/3/17. I received a call from Mr. Lundgren stating that he would not be able to make it to his scheduled oral argument. I took his number and called him back. I called him back and informed him that as he was notified in his letter under Rule 212, E5, his appearance was required. He replied, well, I cannot be there and I am respectfully notifying the court right now by calling in. My response was any information that is intended for the court must be submitted in writing. He asked for our fax number and I gave it to him. And I did not see a fax, and I honestly did not follow up because it was my understanding that this was pretty much a concluded issue. And the fact that he's not here, my concern always is to make sure that they know that they're supposed to be here, and clearly he did.
Well, any questions of counsel? Any further presentation?
No, Your Honor.
Your recommendation today is to disbar.
Yes.
All right. I see nothing further. Thank you, counsel.
Thank you.
That concludes this case that we will take under advisement, and the court